Okay. All right, everybody. It is 6:30, so we are going to go ahead and get started. Welcome and thank you for joining us tonight. I am Leslie Mehalick. I'm an attorney with McAndrews Law Offices. And tonight we're giving a webinar. We're going to be talking all about special needs trusts, and we're going to talk about ABLE accounts too. So we do have a lot to cover tonight. And, we're going to go through a lot. If you do have questions, you can later submit those through our website. So that is McAndrewslaw.com. But you can go on there, and in our contact us area, you can submit questions. But tonight we're going to just try to go through all of this. It's, like I said, quite a lot of information. So what we're going to discuss tonight is we're going to start with why you would use a special needs trust, and we are going to talk about a brief overview of public benefits. That's an area where we really could spend, quite a long time talking, but we're just going to do a brief overview. But it is important to have a good understanding of the public benefits that you want to be watching out for, why you might need a special needs trust, and the benefits that we're trying to protect by using the trust. So we will go through that. Then we're going to talk about the three types of special needs trusts. Then we're going to get into the uses of special needs trusts. How does the trustee spend money? What do you do with them? Can you buy a house? Can you pay for food and shelter? We're going to talk about all of that. And then finally, we will conclude with a good overview of ABLE accounts. And we will specifically talk about the differences between special needs trusts and ABLE accounts, so you can see why you might want to use an ABLE account in conjunction with a special needs trust, or sometimes instead of one. Okay, so with that, we are going to get started. If I am able to move my slides forward. There we go. Okay. There we go. All right, so why would a person possibly need a special needs trust? Well, these trusts are extremely important. They really, really are. As we will learn, the special needs trust is truly the main vehicle that can hold monies for a person who has special needs and who may be getting or may need in the future resource-dependent public benefits. So when we say resource-dependent, it means that the person cannot have too much money in his or her own name and still qualify for the public benefit. The public benefits that we'll see are just truly essential for persons with special needs. But in order to qualify for them, an individual can only have very, very limited funds in his own name. So the special needs trust can provide so many things above and beyond what the basic public benefits can provide. These trusts can truly be used to enhance the quality of life for an individual with special needs, and really can be used to just provide them whatever it is that they would want that they may not otherwise be able to get. So these trusts are extremely, extremely important. It's important to note that as long as we are able to utilize a special needs trust under the law, then that trust can be funded and the individual can immediately qualify for public benefits. So when you hear about that 5-year look-back rule, that is actually a rule that is part of elder law planning. So particularly if an individual over age 65 is looking to do Medicaid planning, that's when that look-back rule is really going to apply. But again, as long as we have an opportunity to properly fund a special needs trust under law, then that 5-year look-back period is not going to apply. Now, for anyone to utilize a special needs trust, they do have to be considered disabled. And when we use the term disabled, we are specifically talking about the Social Security standard that they put out. And I have that standard here on the slide. You can see that it is very different for a person who is under age 18 versus over 18. So for a minor child under age 18, the standard is that they must have a physical or mental impairment that results in marked and severe functional limitations. So as you can imagine, that standard is fairly loose, and many individuals can fit into that standard. Once the person turns age 18, however, for Social Security purposes, they are considered an adult, and we are then looking at the adult standard. The adult standard is very different. It really is an economic standard. Social Security says that the individual must have that medical or mental or physical impairment, but that impairment has to prevent the person from working enough and earning enough money each year. So Social Security puts out a number every year. It's called the substantial gainful activity amount, and that is a monetary amount. And if the individual is able to consistently work and earn gross earnings over that substantial gainful activity amount, then they will not qualify as disabled under this Social Security standard. So as you can imagine, there are many individuals who may be able to qualify for Social Security benefits under age 18. They may be able to qualify as disabled under this looser standard under age 18. And then when they turn 18, if they are high functioning, it can be a lot harder to qualify under this more strict and, again, economic standard. But we'll talk about various reasons why we very much urge families to go to Social Security and apply for benefits upon their child turning age 18. There are many reasons why we strongly recommend this. It's really very important. But just keep in mind that this standard for disability does change depending on the person's age. All right, so we're going to go into our brief review of public benefits. And the benefits that we are focusing on for purposes of this seminar are the resource-based benefits, resource and income-based benefits. And remember, that means that the individual cannot have too much money in his own name. He can't have too many resources in his own name and still qualify for the benefits. So these benefits have resource limits. You must have monies below that resource limit to qualify. So the major one on the Social Security side is called Supplemental Security Income, or SSI. What this is a monthly cash benefit that an individual can get from the Social Security Administration. SSI is administered through the Social Security Administration, or SSA. So these are federal rules, and really the same rules apply no matter where you live in the U.S., but definitely in Pennsylvania, where we mainly practice, but also in the other states in which we practice as well. So if an individual will qualify for SSI, they'll get this monthly check from Social Security. Now, in order to qualify for SSI, an individual has to be disabled under that standard that we said earlier. So they must have a physical or mental impairment that prevents them from maintaining substantial gainful activity. And then also they have to have a total amount of liquid resources that is less than $2,000. So as you can imagine, $2,000 is a very small amount of money. So individuals that are going to qualify for SSI truly can only have extremely limited resources in their own name. As of the first day of every month, their resource limit has to be back below $2,000. And when we say liquid resources, we're talking about any type of bank account, stock account, CD account, any sort of accounts they have. It literally includes money under their mattress and cash in their pocket. It is all of the liquid monies that they have. In addition, SSI also has very strict income limits as well. The maximum monthly payment that an individual can get from SSI right now is $943. Pennsylvania also has a small state supplement that the individual can qualify for, somewhere around $22 per month. Now, when a child is a minor under age 18, the parental resources and income are going to be deemed to that child for purposes of SSI eligibility. So if the parents are working and have any type of monies in the bank, in all likelihood, the child is not going to qualify for SSI under age 18. Once the child turns 18, however, Social Security no longer looks at the parental assets. They're only going to be looking at monies that are in the child's name. So for parents that do have a minor child with special needs, we really don't want the parents to be opening bank accounts in the child's name. If they do that over age 18, those accounts would be deemed as assets in the child's name, and it would have to be spent down before the child would be eligible for SSI. So we really don't want to do that. Now, the parents may be able to do other types of savings techniques, such as creating a special needs trust and putting monies in there to save for the child, or opening an ABLE account where they could save for the child as well. Now, in Pennsylvania, we have a favorable rule in that an individual who gets $1 of SSI, they're automatically enrolled in the Medicaid in the adult system in Pennsylvania. So that is a very favorable rule. So we have SSI on the Social Security side, and on the healthcare side, we are looking at Medicaid. Now, Medicaid is the term that we use federally. In Pennsylvania, we do call it medical assistance, or sometimes I abbreviate it as MA, but it's really the same thing. So we can use Medicaid or medical assistance interchangeably. Now, Medicaid or medical assistance is a joint federal and state program. So there are federal laws about it, but it is administered on the state and county level. In Pennsylvania, it is administered by our Pennsylvania Department of Human Services, or DHS. You would apply for Medicaid at your local county assistance office. There's also an online application through DHS. But again, if your child is getting SSI, then in Pennsylvania, they're automatically eligible for and enrolled in medical assistance. If, of course, they're getting the SSI based on their disability, which is the type that we're talking about tonight, but they'd automatically be enrolled in Medicaid in the adult system. So in Pennsylvania, you wouldn't need to necessarily go and file a separate application, even though they may otherwise be eligible for the medical assistance. Now, because the two systems are linked, what you do see is that if you are terminated from SSI for some reason, then of course Medicaid is noticed as well, and you could be terminated from your Medicaid. You may be still eligible for the Medicaid, but would need to reapply at that point. Now, also in Pennsylvania, any child on the basis of their disability diagnosis will qualify for Medicaid through age 21. And, you know, that's also tied in with the services that the child receives through the schools as well. Now, even though the child may be eligible for medical assistance through age 21, again, we do urge families to go and apply for SSI at age 18. One reason for that is, just as we saw that once they start receiving SSI, they're automatically enrolled in Medicaid in the adult system. So they will be in the system, which is really very important. It's very important because while we hope that mom and dad will be here for many, many years once the child is an adult, we do have to plan for the worst case scenario. So if anything were to suddenly happen to mom and dad, we really do want the child to be enrolled in the adult systems for these public benefits. Sometimes particularly qualifying for the SSI and having that disability determination being made by Social Security, sometimes it can be really difficult. So if you go and apply and you are denied at first, you really need to appeal that denial. We want clients to appeal it right away and to continue that appeal process. If you end up withdrawing your appeal, then you're going to have to reapply, and your new application will be your eventual date of eligibility. But if you appeal a denial, then you can keep your original application date. So that can be very, very important. So even though it can be difficult, we really urge clients to go and do that right away. Now, one other Medicaid program that I think is important to mention, because not everybody seems to be aware of this one, but it is called Medical Assistance for Workers with Disabilities, or MAWD. MAWD is an important program because it does provide higher income and resource limits than regular Medicaid. The resource limit, in fact, is as high as $10,000. In order to qualify for MAWD, the individual does have to work, but it can be limited work. It could include something even as straightforward as dog walking and things like that. And the individual has to be between ages 16 and 65. So if you do have an individual who is working and is earning a little too much to qualify for regular Medicaid, MAWD might be a program for them. MAWD does have cost sharing provisions though. So there are premiums that the individual has to pay. And those premiums increase depending on the amount of income that the individual is making. So you'd really have to, think about whether that is the right program for you or not. And then we have a brand new program. It's only about a year old. It's called Workers with Job Success, or WJS. In order to qualify for this one, the individual must be on MAWD for at least a full 12 months, but it has an even higher income limit than MAWD, and actually no resource limit at all. The WJS, again, does have that cost sharing element just like MAWD does. So those programs are not for everybody, but they are very important in certain circumstances. Now, a different type of benefit from SSI is what we call SSDI. So again, this is on the Social Security side as well. But the difference between SSI and SSDI is that the SSDI, or Social Security Disability Insurance, or Social Security Disability Income, it's often called, that one is actually not resource dependent. So the individual can have monies in his own name and still qualify for the SSDI. Now, a person can get SSDI in two ways, again, for the purpose of our discussion. The first way would be if an individual is working and if they pay into the system for a sufficient amount of quarters and then they become disabled, then they may qualify for SSDI based off of their own work history. So just for example, if I'm in an accident and I become disabled because I have been working consistently and paying into Social Security for, so many years and quarters, I would qualify for SSDI based off of my own work history. And we do have individuals with special needs who work, let's say, for example, if they're working at the local grocery store, they may end up qualifying for SSDI on their own work history. Now, the second way that our clients have a child qualify for SSDI is extremely important. It is called they qualify as a disabled adult child, or DAC or DAC. This is a really important benefit. The way to qualify as a DAC is the individual must be determined to be disabled under that Social Security standard that we saw before age 22. Age 22 here is a bit of a magic age number in the law. I'm not sure what the rhyme or reason of why they picked age 22. I'm not sure what it is. But that being said, it's a very, very important age. If the individual is determined to be disabled prior to age 22, then what happens is when the individual's parent retires and begins receiving Social Security based off of their work history and their retirement, the child is then eligible for SSDI based off of that parent's work record. So what that means is, if we have a child who is getting SSI, they'll get SSI, and we saw that maximum check right now is $943 a month. Sometimes it ends up being lower than that, but that's the maximum. They may start getting that SSI and be on it for many years, and then when their parent retires, the child's check will be increased. It will turn to SSDI, and they will get a higher amount based off of the parent's work history. Once a person is getting SSDI for 2 years, so a full 24 months, then they will start getting Medicare. And they'd get the Medicare in addition to the medical assistance. Now, the reason why it is so important to be in this DAC category is that the DAC category protects medical assistance eligibility. So what happens when you switch to SSDI is that sometimes the individual is getting so much money in SSDI that it puts them over the medical assistance income limit. But if they are in this special DAC category, they will continue to receive their medical assistance despite the higher income that they have. So this is an extremely important category. And this is a very, very important reason why we do want clients to go and apply for SSI at age 18. And again, if you have a high functioning child, perhaps they're on the spectrum and they're high functioning, but they're not going to be able to maintain full-time employment with private health insurance for the duration. If they're denied at first, we really want the family to appeal that denial. And again, keep on with that appeal because as long as it's being appealed, then your original application date will be preserved. And then when the child eventually does get SSI, will have that date of determination of disability will go back to the original application date. But if you just withdraw the appeal and don't go back and apply again until, say, age 25, you can be out of luck. You can always, of course, try to go back and prove that the individual was in fact disabled under that standard before age 22, but it's just a harder road. I mean, to be honest, the easiest way to prove it is to have them actually get SSI before age 22. Because remember, it really is that economic standard. The fact that the individual has a diagnosis is not in of itself enough for Social Security. We have to show that the impairment does in fact prevent them from maintaining that substantial gainful activity every month. So that is what we are looking at. So there really are a lot of reasons of why we want to apply for SSI, but it is a very important thing to do. And, we are very aware it's so much for families. They go through so much to, learn the systems, to find proper doctors, to work through the educational systems when their children are minors. But honestly, once they turn 18, there are, again, a lot of things that the family will need to work through and learn about. So the benefits are very important. So again, when we are looking at these special needs trusts, we really are utilizing them so we can protect eligibility for the SSI and the medical assistance. If they end up getting SSDI and Medicare, we have many clients that will qualify for and receive multiple of these benefits. So we have many clients that will receive both Medicare and medical assistance. They can be dually eligible for both. Sometimes they may even have private health insurance too on top of that. Now, anytime you have multiple forms of health insurance, Medicaid is always going to be the payer of last resort. So private and Medicare are going to pay first. But that being said, Medicaid is very important because it really is the broadest source of healthcare coverage that we have. So Medicaid may come in and pick up some additional copays or premiums or just items that regular insurance and Medicare may not pay for. In addition to the regular Medicaid, we also have the Medicaid waiver programs, and these are very, very important programs. The waiver programs are the programs that provide the supports to allow an individual with disabilities to remain in the community as opposed to going to an institution. When we say institution, we're truly talking about the institutions of old, like in the 1970s and Pennhurst and that type of thing. So the Medicaid waiver programs can pay for group homes, but they also can provide benefits to allow an individual with disabilities to stay in his own home. So through the waivers, they really are supposed to provide any type of benefits that the individual might need to remain in his home. So it may be case management to, come in and monitor the person and, assess what services he needs. Maybe they need some help with house cleaning, or maybe they need services to help drive them around to doctor's appointments and things. Perhaps they need aides in the home to transfer them from the bed to a wheelchair and help with self-care and hygiene and things like that. Those are all things that are provided through the Medicaid waiver programs. So in many cases, even if the individual does switch to SSDI and Medicare, we still want them to retain their eligibility for the medical assistance because it also provides these Medicaid waiver programs. And those are just very, very important. Now, we were talking about how an individual can only have that $2,000 of liquid resources and still qualify for benefits, but the individual is allowed to own certain excludable resources and still qualify for the SSI and the Medicaid. So specifically, a person is able to own their home. It does have to be their principal residence, but they can own their home and they can own one car and still qualify for their SSI and Medicaid. In addition to that, they can have a prepaid funeral or an irrevocable burial reserve, as well as a burial plot. And then also, of course, tangible personal items such as reasonable clothing, jewelry, furniture, electronics, things like that. None of those will disqualify an individual for public benefits. Okay, so that was our quick run through over public benefits. And what we're going to turn to next are the different types of special needs trusts. So there are three main types, but we really can group them into two categories. So the three main types are our third-party funded special needs trusts, and then we have our self-funded special needs trusts and the pooled special needs trusts. So the major difference between these different types is where the money is coming from that is actually going to fund the special needs trust. So the first one that we're going to talk about are our third-party funded special needs trusts. These are the ones that are going to be funded by literally any person in the world except for the beneficiary with special needs. So we'll talk about that first. The third-party ones are the type that a parent may use as part of their estate plan to provide monies for their child's future. And then after that, we'll run through the self-funded special needs trust. Those are the ones where the individual with special needs, if he comes into money, he can transfer his money into a self-funded special needs trust or into the pooled trust. Okay, but first, the third-party funded trusts. So our third-party funded special needs trusts. So these have been permitted in Pennsylvania since roughly 1987. There's a bunch of cases that allow these types of trusts. We don't have any laws in Pennsylvania that are specific to these, and there's no federal overarching law about these trusts. So it's really just Pennsylvania case law. Now, before these trusts came around, parents who had a child with disabilities were really left with very poor choices. In most cases, the parents would have to disinherit their child. So in their will, just not leave anything specifically for the child with special needs. This still can be a valid technique. What we don't want to do is to leave the child with special needs monies that will go into his or her own name. If we do that, that's going to render the child ineligible for their benefits. They'll have to lose the benefits that they're on, and we're going to have to do planning about it. You know, some of the planning can be complicated depending on the situation. We may need to get the court involved. We may have to get a guardianship. There can be a lot of considerations with it. So it really is something that we want to avoid. So before we had the third-party funded trusts, parents really were left with no other options other than disinheriting their child. And again, some people still come into us with wills that do this today. So, you know, while families could try to leave monies to a different sibling and hope that that child will use the monies on behalf of the disabled child, you know, that can work in a perfect world. But the truth is, it's just not a perfect world, and we don't have a guarantee that that will happen as the parents intend. There's a lot of things that could happen that could prevent that result, right? For example, the sibling that you leave the monies to, he could end up deciding to just use it on himself, or he could have a spouse who would much prefer to use that money on them as opposed to the sibling with special needs. The child could end up getting divorced, and that money could end up being split up in equitable distribution. The child could enter into a bad business deal. There could be addiction issues. There could be spendthrift issues. You know, there's a whole lot of things that could happen that might prevent that. So since 1987, we do have the opportunity for parents to do preventative planning and to utilize one of these third-party funded special needs trusts as part of their estate plan. So what they would want to do is in their will, they're going to designate that any share for the child with disabilities is going to go directly into that child's special needs trust and administered according to the terms of that trust. So these third-party funded trusts, again, they can be funded by anybody except for the individual with special needs. He cannot put his own money into this trust. We can never put his SSI check into this trust. That we just can't do. But parents, grandparents, anybody else can leave money to this trust. They are often funded by wills, but they can also be funded by lifetime gifts as long as they're properly drafted. And these third-party funded trusts, as long as we do draft them properly, there is no payback to the state Medicaid agency upon the beneficiary's passing. So instead, when the beneficiary passes away, the remaining trust monies can go wherever the parents wanted. So we can name other children, we could name charities, you know, really we can have it go to anybody that they want, but there's not going to be any payback to the state. These trusts are supposed to supplement public benefits and not supplant them. And that's language that we like to see in the trust document itself. We want it to be very clear that the parent's intent in making this trust is to supplement public benefits and not replace them. So the trustee is always going to consider public benefits before making distributions from the trust. So we just want the trustee to look and say, hey, is this something something Medicaid will pay for? If so, then, we want to try to have Medicaid pay for that because we really do want this trust to last for the child's lifetime and to really be used above and beyond what public benefits are going to provide. Because these trusts are supposed to supplement public benefits and not supplant them, sometimes you will see these also called supplemental needs trusts. That refers to a third-party funded trust. So again, really interchangeable terms. An important part of this and any type of special needs trust that we'll see is that the trustee does have to have total discretion to make payments or not make payments. So these trusts simply cannot pay out all income to the beneficiary, and they're not going to be able to pay out some type of like allowance or monthly payment for the beneficiary. All distributions are going to need to be in the sole discretion of the trustee. Now, with our third-party funded trusts, they can be drafted in two different ways, and both are absolutely fine. The first way is what we call testamentary. That means that the trust itself is actually contained within your will. So it is written into the will, it is part of the will. So you can have one will that contains your special needs trust. That means that that special needs trust does not come into existence until the person who wrote the will, the testator or the parent here, until they pass away. At that point, the executor of their estate, once they're ready to distribute to the trust, they'll, have the trustee set up the trust and make distribution to the trust. So if it's a testamentary trust, it doesn't come into existence until the person who wrote the will passes away. The other option is what we call an inter vivos trust. Inter vivos just means during lifetime. So that means that the parents are setting the trust up during their lifetime, and it is a separate trust document from the will. So once mom and dad sign the trust, then the trust comes into being. It does not mean that you have to put money into it right away. They could just hold it and not fund it until they pass away. But the trust would exist outside of the will. In general, that tends to be the preferred way that we often draft these. And the reason is because if it is this inter vivos trust, you do have the opportunity for lifetime gifting. So just for example, if mom and dad want to do a gifting plan to the trust to lower their estate for tax purposes, they can do that into the inter vivos trust. They'd open a bank account and then they can do annual gifting. Or if it's simply that, every child's birthday, the child is getting some birthday checks from various family members and the parents want to save that, we can put those gifts directly into the inter vivos special needs trust. Sometimes monies will be like fundraised through the community. We can put those directly into the third party trust. Also, having it as an inter vivos trust does allow for other family members to name that trust in their will as well. So for example, if you have grandparents that say want to leave $5,000 to every grandchild, in this case, the grandparents can just name the third-party funded trust that mom and dad already set up, and they wouldn't have to, go to an attorney and pay to have a whole other special needs trust set up. So you have a little bit more flexibility and options with the inter vivos trust, but again, both ways are absolutely fine. What we do want to make sure, though, is we want to be sure that the client coordinates their entire estate plan with the special needs trust. So we want to be aware of both our probate assets. Those are the assets that pass through your will, and then our non-probate assets. Those are the assets that pass outside of your will. We have to coordinate all of those with our special needs trust. So the probate assets that pass under your will are going to be accounts in your own name. So it could be a bank account, a brokerage account, anything like that, that is owned by the person who passes away individually. It could be their house, anything else like that that they own in their own name. In contrast to that are assets that are non-probate. Those are assets that are going to pass by beneficiary designation. So our non-probate assets are going to include things like life insurance or retirement plans. Those pass completely outside of your will. It doesn't matter what your will says. Your non-probate assets are going to pass to whoever you name in the beneficiary designation. So if you have a child with special needs and if you are doing an estate plan for them, and if we set up a special needs trust, it is extremely important that you go ahead and modify the beneficiary designations. We specifically want to name, the third-party funded special needs trust for my child, so-and-so. We want to specifically name that trust on the beneficiary designation. I just can't overemphasize this enough because this is an area where, we see people come in where they had a great trust, but they never updated their beneficiary designations, and the child could end up inheriting monies outright, which again is what we absolutely want to avoid. We also just have to watch for other assets that are in the child's name. Like I said, we don't want to be putting bank accounts in that child's name, but depending on what the asset is, it could be an available asset to the child that would disqualify them for public benefits. So if they do have any type of custodial account, that's the UTMA account, Uniform Transfer to Minors Act accounts. Once the child attains the age of majority, those are fully deemed assets of the child. We could not put those into a third-party funded trust because those are the child's money. And remember, our third-party funded trust can be funded by anybody except the individual with special needs. So we'd have to do other planning if they had one of those custodial accounts. Those 529 plans are different, though. They're controlled by the plan owner. So as long as your child is not the plan owner, even if they're named as beneficiary, it won't disqualify them. So a few years ago, we had the passage of the Secure Act, and you may be familiar with it, but this really changed a bunch of the rules for inherited IRAs. They said in general, when a child now inherits a traditional tax-deferred IRA, then the child can only has 10 years in which they can take the proceeds of the IRA out. They used to be able to stretch it over their lifetime. Now, an exception to that is if you are leaving that tax-deferred traditional IRA to a special needs child, which we would not want to do because that will disqualify them for public benefits. But another exception is if it is left to a properly drafted special needs trust. So a special needs trust that is drafted properly can still get the benefit of the lifetime stretch of a traditional IRA. It means the IRA can be stretched out over the beneficiary's lifetime. It's designed to give us the best income tax result that we can get. Now, that being said, it's still complex, and this type of planning is complicated, and we really have to look at each individual case very carefully. But what would happen is the IRA monies can pay into the trust. And the reason why we have to be careful is because trusts do pay income taxes at a compressed schedule. So we actually get to the highest tax rate a lot faster than we would with an individual. So that means we have to do some real planning and work with the trustee about what distributions might need to be made from the trust each year in order to get the optimum tax benefits. So again, it's kind of complicated planning, but definitely something that we can work through. Before the Secure Act, if a family had a traditional IRA, we might look to see if we could leave that to other children and not the disabled child. And we still might do that because of these other tax issues that I'm talking about. But again, that planning really depends on the family circumstances, on who the family members are and what the total assets are. So it's something we really look at carefully in every case. Okay, so we did our brief overview of our third-party funded trusts. Again, the third-party or supplemental needs trusts are the ones that the parents might use as part of their estate plan. So in their will, they could include terms to leave any share for the child with disability directly into the special needs trust. Now, we're going to turn to our two types of self-funded special needs trusts. So we'll review our individual self-funded special needs trusts, and we will also talk about the pooled special needs trusts. So first off, our individual self-funded special needs trust. So when would we use this? What is it for? This is the trust that the individual who has special needs, if he has money in his own name, he may want to transfer this money into the individual self-funded special needs trust in order to become eligible for public benefits. So sometimes we'll do this if the individual is in a car accident, or maybe there was a medical malpractice action on behalf of the individual. And if they get money through a lawsuit settlement, we can transfer those monies into one of these types of special needs trusts. And again, they are immediately eligible for public benefits, so long as they would otherwise be eligible if they meet the disability requirements and they don't have any other assets in their own name. So these trusts are governed under both federal law, and we have that here, and also state law. So Pennsylvania has a statute as well as to these trusts, and we do have to follow both of those laws very carefully when we are doing this type of trust. Again, so we could use it if the individual got a personal injury action, but let's say mom and dad had a life insurance policy. Let's say it was $50,000, and they never got around to updating that beneficiary designation to name the special needs trust that they did, and it just named the child, and the child inherits $50,000 outright from the life insurance policy. We would look at utilizing this type of trust in that circumstance. So there are a lot of requirements about these types of trusts. So first of all, an individual with special needs can only fund one of these trusts if he is under age 65. That requirement is very strict, and they adhere to it exactly. So as long as the person's under age 65, they can move their monies in. But once they turn 65, you can no longer do it. Additionally, these trusts have to be drafted for the sole benefit of one individual who is disabled under that Social Security standard. And then we're also limited in who can create this trust on behalf of the individual. We are now allowed to have a competent individual with special needs. He can now self-settle his own self-funded special needs trust. Or if the person's not able to do so, if he is a minor or he's incapacitated and he can't do that, then it's going to need to be his parent, his grandparent, his court-appointed legal guardian. And if we don't have any of those, then we can go to the court and ask the court to establish this trust on behalf of the individual. But we are limited to those persons who can actually establish this type of trust. These trusts do have to be irrevocable. So once the individual puts his money into it, it's irrevocable. He's not going to be able to revoke it or just take that money out. Importantly, these trusts do have to provide that when the beneficiary passes away, any monies that are left over in the trust must be made available to the state and used to repay all of the Medicaid provided to the beneficiary. That Medicaid payback does go back over the beneficiary's lifetime. It's not limited to the term of the trust. It can go back for their lifetime. That payback is going to have to be satisfied before other distributions are made from the trust. And particularly, they won't let you pay for the individual's funeral until you pay the Medicaid payback first. So sometimes you can negotiate that with the state, but the law says you are first supposed to repay Medicaid before the funeral costs. You can get around that by prepaying for the funeral during the individual's lifetime. Now, that payback for Medicaid, it is literally only for the Medicaid that is actually paid out on the beneficiary's behalf. So when Medicaid is paying out, they do have negotiated rates with providers, and they are typically paying much less than what private insurance would need to pay. So you only have to repay what Medicaid actually pays out. You can request what they call a statement of claim from DHS that will list all of the outstanding Medicaid charges that they have record of, so you can always see what a potential payback may be. Now, the pooled trusts are another type of these self-funded trusts, but they operate very differently. So with the pooled trusts, they actually have to have a non-profit fiduciary as the trustee. There are several of these that are set up in Pennsylvania and in other states. If you Google, you can pretty easily find them, and we can always give you suggestions for them. But they do have to be run by a nonprofit. The nonprofit is going to have a master trust agreement that they have had drawn up, and they have gotten approved by the state. All of these self-funded trusts do have to be approved by our state Medicaid agency, by DHS in Pennsylvania. So they have a master trust agreement that's already drawn up and that's been approved by the state. So in order to join the pool, the individual just needs to complete a joinder agreement, and then they can transfer their monies into the pool. In the pool, the trustee is going to maintain individual accounts for every person participating, and those accounts will be maintained for the individual during his lifetime, but the accounts are going to be pooled collectively and invested all together in order to get the greatest investment return. At the death of the beneficiary, it is going to depend on what the master trust agreement says, but in many cases, the remaining monies that are in his individual account, they will remain in the pooled trust. They have like a general account, and the monies will go there, and then it's in the trustee's discretion what those monies can be used for. And again, the master trust agreement will typically discuss this, but sometimes they can use the monies for other participants in the pool that may not have sufficient funds in their individual account for things that they need. Now, one thing to note is that the federal law does allow transfers to the pooled trust over age 65. So we saw with our individual self-funded trusts, we absolutely cannot put any monies into those trusts once the person turns age 65. It's a big, hard no. With the pooled trust, though, the federal law actually does allow transfers over age 65. However, in Pennsylvania and many other states, what they have said is that they will treat a transfer to a pooled trust over 65 as a gift or a transfer for less than fair market value. And so what our state does is they look at the amount of money that was transferred in, and they will determine a penalty period based on the amount transferred. And during that penalty period, the individual is not going to be eligible for their Medicaid, and that would include their Medicaid waiver benefits. So right now, unless we have a very, very unique case, we're not making transfers to the pooled trust over age 65. Other states do allow these and don't assess that penalty period, though. And we've even seen a state or two change their opinion and, stop assessing that penalty period. So it's something to watch out for. Perhaps it will change down the road. Okay, so we're going to turn to a discussion about the administration of these special needs trusts. So we'll really go through what these trusts can and cannot be used for, how payments are made. We'll talk about limits. We'll talk about the trustee's job and all of that. Okay, what can a special needs trust purchase? So sometimes we hear clients that come into our office say that they don't want to use a special needs trust because they have heard that it's very, very restrictive and it can't do all kinds of things. So they don't want to do it. Well, as long as your trust is properly drafted, that is just not the case. These trusts truly can be used extremely broadly to really enhance the quality of life of the individual with special needs. They really, really can be used very, very broadly. So, you do want to make sure that you are working with somebody that really understands these trusts and understands the nuances of the public benefit rules, because you don't want a trust to be drafted in an overly restrictive fashion. You want it to be broad so it really can be used for the individual. So I have a couple just examples of things that these trusts can be used for here on this slide, but they absolutely can be used for things like clothing, a car, even if the individual can't drive. The trust can can still buy a car for the individual. It can pay for a driver if that's needed. Of course, it could pay for any other types of transportation, if they need a bus pass or a train pass, anything like that. Can pay for any types of electronics, computers, cell phone, whatever it is that they need. Of course, any type of adaptive devices that might assist with their disability, but certainly can be used, for any type of electronics that they would want. It can be used to pay for a vacation. That's for the individual and whoever is needed to accompany the individual on that vacation. So if persons are needed to help care for the person, if you need nurses, or if they have to be accompanied 24 hours a day, more than one person is allowed to go and be paid for on the vacation. It just does have to be people that are actually needed to care for the individual. So, it could be like, say, mom and dad and a nurse, and the trust can pay for all of them. But if maybe minor siblings are going as well, then the trust is not going to pay for those minor siblings because they're really not needed to care for the individual. But the trust can pay for any type of entertainment costs. It can pay for, Phillies tickets or concert tickets, whatever it is that the individual would enjoy. And of course, we can prepay for the funeral. That's always a good thing to consider when setting up this type of trust. So on our website, McAndrewslaw.com, we have an article that clients really like. It's called The ABCs of Uses of Special Needs Trusts. And it just gives an alphabetical list of just examples of things that these special needs trusts can be used for. And, you'll get a couple chuckles in there because it has everything from pet food for the individual's pet to, I don't know. I always think of V, and I know they used valise in there, although they should have just done vacation, I feel like. But it just has a whole laundry list of examples of items that are appropriate and can really ease some people's minds when utilizing this type of trust. So sometimes we say it's almost easier to talk about the things that the special needs trust cannot purchase as opposed to the things that it can purchase, because again, as long as it's drafted properly, it really can be used extremely broadly for the individual. So what can't they do? So, we generally are drafting these trusts for the individual's sole benefit. If it's the self-funded trust, it must be for their sole benefit. If it's the third party, it may not be, but it often is. So if it is drafted for the individual's sole benefit, we simply cannot make major gifts to other people. This trust is for the disabled individual. And really, that is a rule that really serves to protect our individual. A lot of our family members who do have a child with special needs are very concerned because it's a very vulnerable population. And, you know, we really don't want them to be convinced to give their money away to any bad or designing persons out there. And we all know that there are far too many bad actors out there. So in these cases, the trustee is actually hamstringed and they're not going to be able to make any of those gifts. So it is an important thing with the trust. Now, that being said, if the individual who has special needs himself, if he gets enjoyment from, say, picking out a reasonable gift at a customary time, let's say it's his mother's birthday and he wants to purchase, you know, something small. But if he gets joy out of that, then the trust can buy that. But it is absolutely not buying like a car for, you know, a sibling who lives across country, or it's not going to give $1,000 to, you know, their friends or anything like that. So no major gifts. And then also no cash. These trusts are not an ATM machine. They are just not an ATM machine. The individual cannot get cash from the trust. Getting cash from the trust is treated as income and it will affect their public benefits. You know, for purposes of this talk, I didn't want to get too deep into the income limits for SSI, but SSI says that the individual can have up to $20, a whole $20 a month of unearned income. That would be like if the trust gives out cash, right? That's unearned income to the individual for purposes of SSI eligibility. So if the trust gives the individual any more than $20 per month, that is treated as income for SSI purposes, unearned income. It's reportable to Social Security. It's going to reduce their SSI dollar for dollar. And that $20 rule is really a de minimis rule. It's supposed to be like if mom and dad take the kid out for lunch or something like that. It's supposed to really cover that. So we're simply not giving cash from these types of trusts. So instead, we are going to have a trustee in place that is going to make all purchases directly. If it is a major purchase, let's say they're buying that vehicle, they're going to write a check directly to the car dealer. Today, with online payments, you can do a lot of payments directly via online. And then also, if we have a competent beneficiary, he can use his own credit card and he can make purchases, and then the trust can pay that credit card statement. That's allowed because the credit card bill is treated as a debt, and the trust is allowed to pay a proper debt of the beneficiary. So again, you know, where we can, we'll have the trustee pay the vendor directly, but the trustee cannot provide cash to the beneficiary. We just don't want any cash to get into the beneficiary's name. But we can use credit cards. So it is important, if the beneficiary is going to use a credit card, it must in fact be a credit card. If they use a debit card that's linked to the trust, the debit card can get cash. So that's a no-no. Social Security won't let you use a debit card. It does in fact have to be a credit card. And I put the name of a particular product on here called the TrueLink prepaid card. There are other ones out there. This one happens to have made its way into the Social Security regulations, so they've kind of blessed this one. But what it is it is a prepaid card, meaning that the trustee can load a certain amount onto the card when at whatever times they would like to. So let's say they put $200 on it for the month, then the beneficiary can spend that $200, but they're not going to be able to overdraft it or anything like that. Once that $200 is gone, you know, the card will just be denied at that point. The trustee can make reimbursements to third parties. We just want justification for the purchase. So, you know, if somebody else is buying something for the beneficiary, we're going to want them to provide a receipt to the trustee. And of course, the trustee still has to approve the payment. So if it's any large payments, we always want to get that approved ahead of time. Okay, what about food and shelter? You may have heard these rules that the Special Needs Trust cannot pay for food and shelter. What is the deal with that? Well, first of all, if the trust, again, is properly drafted and broadly drafted, it very well may be able to pay for food and shelter. All of the ones that we draft have the ability to pay for food and shelter. It's just a question of whether it is the right decision to do that, but in many cases it is. So what's the deal with this rule? Well, for SSI purposes, Social Security treats income very strictly, as we said, and they have different rules depending on the different type of income that an individual might get. So I just discussed this rule that they have for unearned income. That's where you can only get $20 a month. Any cash above that is treated as unearned income, and there's a dollar for dollar reduction of your SSI payment. They have a little bit of a different rule for earned income. So if your child is working, again, let's say at that grocery store and they are earning monies, you'll see their SSI check may fluctuate month to month depending on how much they're earning. That's because Social Security will count the first $85 of earned income. They'll just discount that. And then after that, they do basically a 50 cents on the dollar reduction of that person's SSI. So you may see it fluctuate. Unfortunately, you are going to need to monitor the child's hours when they're working because we don't want them to earn so much money that they lose their SSI eligibility. Remember, if they get $1 of SSI, they're automatically eligible for Medicaid. So, even if it's lowered a little bit, as long as they're getting some, they'll be okay. So Social Security has another kind of income that they call in-kind support and maintenance. This is usually abbreviated to ISM, and people call it ISM a lot, ISM payments. What in-kind support and maintenance, or ISM, is it's this rule Social Security has, and they say that if anyone other than the SSI recipient, if anyone other than the SSI recipient pays for the SSI recipient's food and shelter, then that is treated as this type of income to the beneficiary. It's treated as this ISM income to him. The rationale here is that the individual's Social Security, that $943 a month that they're getting, that is supposed to be sufficient in Social Security's eyes to pay for the individual's food and shelter. Now, maybe if they're in Section 8 housing and if they have food stamps, maybe they will be able to pay for their food and shelter through their SSI alone. However, as we all know, it's just not always feasible. Section 8 housing can be very hard to get. It may not be appropriate in every case. And there's many times where their actual food and shelter costs are simply going to exceed that SSI amount, and they're going to need help from another source. So if somebody else is paying for their food and shelter, and again, this could also be in the case where you have an adult individual with special needs who's living rent-free in his parents' house, or it could be in the situation where the Special Needs Trust is, say, paying $1,500 a month of rent for the individual. It's treated the same in both cases. But in those cases, Social Security does say that those are these ISM payments, and what they will do is they will reduce the individual's SSI. Now, the good news is that they will not eliminate it, they just reduce it. So they have an amount out there. It's called the presumed maximum value. It's basically 1/3 of the current SSI amount, and that's the amount at which they will reduce the individual's SSI every month. So even if, again, that trust is paying out $1,500 a month of rent for the individual, Social Security will only reduce the person's SSI by that 1/3 amount. So in many cases, it might even make sense to have the trust still pay that rent and only get your SSI reduced by that 1/3 amount. So something, to look at. Now, these ISM rules are changing a little bit in September of this year. Currently, this in-kind support and maintenance includes shelter, but it also includes food. So food is going to be the typical groceries. But that rule is going away. So as of September, I think 30th, the end of September of 2024, the ISM amounts will only include shelter costs. So shelter costs are mortgage and rent payments, and then essential utilities. So shelter costs include things like electric, gas, water, sewer, trash removal, things like that, the essential utilities. Shelter costs do not include something like phone or internet or cable TV or anything like that. It's only the essential utilities. This is, and you'll see if you look at our trust, we draft them broadly. We don't, specifically reference a lot of things, and we keep it broad on purpose, specifically because the regulations and the rules in this area of law are continually evolving. I mean, this is just one example, but, the food has been part of this ISM for quite a long time, since its inception. And, now it's just suddenly changing. The ISM rules used to include clothing, but that rule went away, I think, back in 2006. So since then, it's just been food and shelter, and then moving forward, it will only be shelter costs. Okay, so we have now talked all about public benefits. We've talked about our 3 different types of special needs trusts, and we have talked all about the uses of these trusts, how payments can be made, and all of that. So with our remaining time tonight, we are going to turn to the ABLE accounts, and we will discuss these accounts, and we'll particularly discuss how they differ from special needs trusts. We have a lot of clients that are utilizing both an ABLE account and a special needs trust. So for the reasons that we're going to discuss, we will see that in most cases, the ABLE accounts are not replacing special needs trusts. There's some limits on them that really don't make them a replacement for most special needs trusts. They are not replacing the third-party funded trust that you would do as part of your estate plan. They're simply not a substitute for that type of trust. And in most cases, they're not a substitute for the self-funded trust either. But if you have a smaller settlement, it might be a good alternative in that case. So we'll go through it. But this really is a very exciting piece of legislation. It was, one of the most major changes in legislation that we've had for individuals with special needs in quite a long time. And we're really excited to see this. So what the ABLE accounts are savings accounts that an individual with disabilities can have and can still qualify for his public benefits. So we'll see all the rules, but an individual can still get SSI and Medicaid and have an ABLE account. And one of the great things about the ABLE account, as long as it's the right fit for you, is that the individual can have much more direct control and access over the ABLE account. Okay, so we will go through it. So the ABLE Act, Achieving a Better Life Experience Act, this was a federal law. It was passed by Congress back in December of 2014, and it allowed states to enact their own state legislation, which would enable a person with disabilities to fund a savings account that, again, is not going to be countable for SSI or Medicaid eligibility purposes. The law was modeled on State 529 plans. It's Section 529A of the tax code. In order to qualify, so some basics for the ABLE account. So right now, in order to be eligible for an ABLE account, a person does have to be disabled prior to age 26. We're basically looking at the same disability standard that we saw for Social Security purposes, that substantial gainful activity. Now, that age limit is actually going to increase to age 46. So that will be great. That's going to give us a lot more flexibility. That will increase to age 46 starting in 2026. Additionally, a person can only have one ABLE account. And we'll see they're state by state. So if you have a Pennsylvania ABLE account, that's it. You can't open one in another state. You are able to open your account in a different state if there are rules that would make it more favorable to do that. But once you do that, then you can't open one like in your home state then. And there are some reasons why, it may make sense to open a Pennsylvania ABLE account if you are a Pennsylvania resident. So we'll go through that. Now, the ABLE accounts are interesting because they can be funded by the disabled beneficiary as well as anybody else. So anybody can put their money into the ABLE account. So we saw with the third-party funded trust, they can't be funded by the individual with special needs. And in the self-funded trust, nobody else would want to fund those because they have those payback requirements. So those are really only funded by the disabled individual. But the ABLE account is different. They can be funded by the person with special needs and anybody else. So, again, that really does provide for some flexibility in the uses of these accounts. In Pennsylvania, when you open the ABLE account, you'll do it through the ABLE website, paable.gov, I believe it is, and you can open your account. The funds are going to be maintained through the state. They give you various options for investment options. You can pick from more conservative to a little bit more aggressive with investing, depending on your time frame and all of that. But the state is going to do that investing. There's not a self-administer option in Pennsylvania yet. So with the special needs trust, and this is for all of the types of the special needs trust we talked about, the pooled trust, the self-funded, and the third party. All of them have a trustee in place. And remember, that trustee is the gatekeeper. That trustee says yes or no before making payment. So, if the beneficiary wants something, he has to first ask the trustee, and the trustee is going to look and see if it's appropriate, see if the individual has enough money to make this purchase, and then they would do it as long as they believe it's appropriate in that beneficiary's best interest. ABLE account is different, however. There is no trustee in place. So if you have a competent individual, not someone who's going to be incapacitated or under guardianship and, needing a legal decision maker, but if you have a competent individual, he can have control of his own ABLE account. And, the exact things that the individual can do with the ABLE account may depend on your state. But in Pennsylvania, the individual can have a debit card to the account. He can withdraw funds from the ABLE account and put them right into his own checking account and spend them as he pleases. So, this can be a good way to use an ABLE account in conjunction with a special needs trust. Perhaps the trustee of our third-party funded trust is going to make a transfer, let's say $5,000 from the trust to the ABLE account. They can do that so that the beneficiary can have that $5,000 to use, on his own behalf. As he sees fit. And by having control over those monies and being able to use those monies as he pleases can really enhance the individual's independence, give him greater confidence, and, maybe make him a lot happier with his life. So, that can be a way that the ABLE accounts can really work together with the special needs trusts. So again, the withdrawal methods may vary depending on your state plan, but there's lots of options. Pennsylvania does have that debit card option, which I know a lot of people do like. Now, we mentioned that these ABLE accounts are based on 529 plans, so they do have similar tax savings benefits. So particularly, you put after-tax dollars into the ABLE account, and then while the monies are in the account, they're going to grow income tax free. So you don't have to pay any income tax on the growth of the assets while they are still in the ABLE account. And then when the monies are withdrawn, as long as the account monies are used for the person's qualified disability expenses, then you do not pay income tax on any growth portion. So it does have that income tax savings benefit, just like we see with a 529. So no income tax on the growth as long as the monies are used for qualified disability expenses. What are those? Well, the IRS has given us, and Social Security, they've given us a general list. I put it here on this slide. It says that they include things such as housing, transportation, employment, training and support, assistive technology, health prevention and wellness, financial management, legal fees, expenses for oversight and monitoring, funeral and burial expenses. So it's just a list. It's not exhaustive. It's just a list of examples. Now, the IRS has specifically said that the term qualified disability expenses is supposed to be broadly construed. So it is allowed to include basic living expenses. It's not limited to things for which there is a medical necessity. And it's also okay if the expense provides a benefit to a person other than our disabled individual. So incidental benefit to another is okay. That actually is okay with the Special Needs Trust too, at least it is in Pennsylvania. So as we can see, in my view, they are telling us it's supposed to be broadly construed, and I think we can construe it broadly. On the list that we see, from the regulations, we are not seeing things like the movie tickets and the Phillies tickets at pure entertainment. However, I think under prevention and wellness, that's probably a category that can be broadly construed, and certainly could include, some more entertainment type of expenses. You can certainly imagine a trip to the shore or something like that could definitely, I think, fall into that category. So, we'll probably see more specification of this come out as we see more and more ABLE accounts being entered into. But for the moment, I do believe that these, terms are supposed to be very broadly construed. So as we saw, there's not going to be income tax on the growth part of the distribution, so long as it's for a qualified disability expense. If, however, the distribution is not for a proper qualified disability expense, then there will be income tax on the growth plus a 10% penalty. So very similar again to that 529 plan. Now, a big difference between the ABLE accounts and special needs trusts is that distributions from ABLE accounts are not income to the beneficiary for purposes of SSI. So, how I was talking about this $20 of unearned income from a special needs trust, if you do any more than that, it affects their SSI, and that's why they can't get cash from the special needs trust. Well, that rule does not apply with the ABLE account. The individual can get cash from the ABLE account. It is not treated as income to him, and it will not affect his SSI. So that's a big, big difference. So that means that the ABLE account can pay the shelter expenses, and there is no reduction in SSI. So again, maybe you have a special needs trust set up, and maybe the special needs trust funds the ABLE account every year. And we do that in order to have money in the account to pay for the individual's rent. So that can be a really, really good way to do it. Now, we saw that anyone can fund the ABLE account, but unfortunately, we'll go back to that last one. We are limited in how much can go into the account every year. So due to these limits on the contribution amounts, this is one of the reasons why the ABLE accounts are not a full substitute for special needs trusts. Frankly, the ultimate legislation was a little more limited than we anticipated when it was being discussed. So the rules that we have are that the total yearly contributions to the ABLE account from all sources. So, this includes, so it's one contribution limit. But the total contribution limit is going to be capped at that year's federal gift tax exclusion amount. So currently it's $18,000. So right now in 2024, a total of $18,000 can be put into the person's ABLE account. So if the special needs trust puts 18 in, then that's it. We're done for the year. And we can't do, any more. Now, there is one exception to that, and that is if the individual with special needs is working and earning his own income. If he is working and earning income, then he can actually put monies into the account above and beyond that $18,000. He can put monies in up to the lower of his total earnings or the current federal poverty limit for an individual. So whatever that would be at the particular year, but he could put his monies in over that. Other than that, though, we are capped at that $18,000 limit. You are allowed to make a direct rollover of monies from a 529 plan to an ABLE account. So if you did set up a 529 for a child with special needs, and if it turns out they're not going to use that for higher education, of course, there are some rule changes. You may be able to use it for other educational costs, besides just college and beyond. But if you're not going to use it, you could look at doing a rollover of $18,000 from the 529 to the ABLE account. That would preserve the tax deferred nature of it. That would count as that year's contribution to the ABLE account. So if you do that full rollover, you wouldn't be able to make any other contributions to it. They've also said that assets moved from a trust to an ABLE account are not going to be treated as income to the beneficiary. So in addition to that yearly contribution cap, we also have to be cognizant of the maximum value in the trust, or the total value in the ABLE account, so particularly if the ABLE account exceeds $100,000, at that point, the individual's SSI will be suspended. So once it goes back below 100,000, their SSI would resume. So in general, we don't necessarily want these accounts to be funded in excess of that $100,000. Medicaid eligibility would not be affected, but the individual's SSI eligibility would be. Okay. Now, the federal law for the ABLE accounts does allow a payback to the state for Medicaid provided to the individual. It's a little different than the special needs trust payback because it does say that the payback is limited to the time the ABLE account has been in effect. So it's a limited payback. It doesn't go back for the lifetime, but it is still a payback. Now, Pennsylvania has specifically said that they are not going to enforce this payback from a Pennsylvania ABLE account. So if you have an ABLE account in another state, they may still assert a payback. But if it is a Pennsylvania ABLE account, they have said they will not enforce that and will not try to get paid back from that account. That being said, the account could still be subject to our state's Estate Recovery Act. if the individual passes away over age 55. The Estate Recovery Act is the law that says that if an individual dies over age 55, there is a payback to the state for the Medicaid long-term care that was provided to them over age 55. So the ABLE account, if it does pass to the beneficiary's estate, just be aware that the Estate Recovery Act is out there and there still could be a payback from that. But it wouldn't just be a payback under our state's ABLE law. So if you are a Pennsylvania resident, there are some benefits to utilizing a Pennsylvania ABLE account, although again, you certainly could do a different state's account as well, or instead, because you can only have one. So the reasons why you might want to consider a Pennsylvania ABLE account are that there is no Medicaid payback at the Pennsylvania ABLE account's termination. Remember, the federal law allows it, but Pennsylvania has said they are not going to enforce that. Additionally, Pennsylvania has said that it will allow a Pennsylvania income tax deduction for contributions to ABLE accounts. So Pennsylvania also allows a state income tax deduction for monies that are put into a 529 plan. So they're doing the same thing with the ABLE accounts. There is no federal income tax deduction. You put in after-tax dollars federally into the ABLE. But at least you can get the state income tax deduction. And then additionally, they've said that the entire account, the savings and the growth, is not going to be subject to Pennsylvania inheritance tax. Now, another big difference between the ABLE accounts and special needs trust are the reporting requirements. So with the ABLE accounts, the states do have to report to Social Security. They do report the account balances to Social Security. With special needs trust, there's no, at least not in Pennsylvania, there's no affirmative reporting requirement that is needed. Of course, Social Security can always audit, Medicaid can always request information as to, how much money's in the trust, what it's been used for, and you do have to truthfully respond to those inquiries. But in general, there's no affirmative reporting requirement. And ABLE is a little bit different. The states do report the account balances. So what this means is, let's say your ABLE account, has $50,000, and that's the balance that's being reported to Social Security. And let's say our individual with special needs takes out $40,000. So, we're left with a much, much smaller account. Social Security theoretically may see that, and they could audit it. They could ask the individual what he used the money on, to make sure it was a proper qualified disability expense. And, they would have to report that. So, just be aware that that is, they do send these account balances, and, Social Security presumably reviews them. So the limitations that we have with the ABLE accounts and why they're not replacing special needs trusts, first of all, it's that major limitation about the contribution amount. We can only put up to $18,000 per year, unless, of course, your beneficiary is working. And then we saw that if the account balance exceeds $100,000, the individual's SSI would be suspended. And on top of that, there is that potential payback to the state for Medicaid provided to the individual. We currently don't have that in Pennsylvania, but who knows, what might happen in the future. There is that reporting requirement to Social Security. And then again, we must remember that you're only eligible for an ABLE account if you were in fact disabled before age 26, although that is going to increase to age 46. Now, that being said, these accounts are particularly useful in a number of circumstances, and they really do work very, very well in conjunction with special needs trusts. So we have just a couple ways here on this slide where we are really using these accounts. So if we have an SSI recipient who is working, and we have a lot of clients in this situation, they're earning income, and we don't want them to earn too much income, and we don't want them to accumulate too many resources because they still can't have over $2,000 in their own name and qualify for their SSI. So what the ABLE account does is it allows them to put any excess resources they might have into that account, and then it can be used as a savings account for them. So if you do have a child who is working and still getting SSI, the ABLE account is great for them. You can put the extra income in and they can use it down the road as they need. We're not allowed to do any type of direct deposit. The income that they earn is still earned income for SSI purposes, but once they earn it, then it can be moved into the ABLE account. If an individual is getting a small inheritance or lawsuit settlement, the ABLE account is a great place to put it. So as long as it's under $18,000, and if you haven't made a contribution for the year, they can put it into the ABLE account and retain full eligibility for their benefits. Sometimes we'll do spend downs for people over age 65 because they can still move money into the ABLE account. They just have to have been disabled, again, right now prior to age 26. If you have a beneficiary who is competent, the ABLE account is a great way to give him some more control and ownership over a source of monies. So we, could have a trust, pay money to the ABLE account for that purpose. If they are getting a lawsuit settlement or sometimes an inheritance, we might put the first 18 of it into the ABLE account, again, to have an account where they can have more direct control over it, and then put the remainder into a special needs trust. So those are just some of the uses where we're really utilizing this type of account. But again, it's really not the best vehicle for a larger lawsuit settlement or inheritance other than the first $18,000. And it's just not a substitute for our third-party funded special needs trust with that $18,000 cap on it, with the fact that you can't have an individual trustee in place, with that Social Security reporting requirement, all things that you're also limited into who you can name as contingent beneficiaries for the ABLE accounts. So it's just not a replacement for your third-party funded trust that you would do as part of an estate plan. But we do have lots of clients that are utilizing both a special needs trust as well as an ABLE account for really maximum flexibility. But again, it's very individual determinations, and we would be more than happy to talk with you about your own unique circumstances. All right, everybody. Well, thank you very much. That includes our presentation for tonight. Again, if there are questions, please go ahead and submit them through our website, and we'll be happy to respond as quickly as we can. But I really do hope you enjoyed the presentation. We also have a lot more information on our website, McAndrewslaw.com. Where we have a lot of articles on there, and we really try to provide a lot of free information on there for you guys. All right, everybody, thank you so much. I really appreciate your time tonight.